right, so why are you speeding in a vehicle? How old are you?
29.
I'm sorry, when?
20?
20.
Yes.
And so you speed in a vehicle, a Dodge Charger. So I guess you loved hearing the engine rev.
Sorry.
And no, I mean, this is just what happened. And then you crash into a tree and you take off running. And the females in the car, was one of them your girlfriend?
Jason Wolf for defense.
And are you Mr. Yanes?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review that with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Yanes, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor, and for the record, I've represented him less than 10 days, but he is ready to proceed in waiving that timeframe.
Okay. State, are you proceeding on the indictment as presented?
We are, Your Honor.
All right, everyone, just have a seat. I'll call up Mr. Uresti. All right, Mr. Yanes, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with evading arrest, detention in vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Oh, I am so sorry. I'm doing 3 things at once. Let me go back. Did you understand you have a right to jury trial?
Yes, ma'am.
Did you understand you have a right to confront any witnesses against you and the right to remain silent?
Yes, ma'am.
Did you understand by entering this agreement, you're giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into an agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, I could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do, Your Honor.
Mr. Yanes, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at an $800 fine. State recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney?
Yes,
Did
ma'am.
you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
All right. In defense, for the record, did you go through and re-sign?
I did, Judge. I went through every bit of the documentation and re-signed.
All right. Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation and 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments.
All right,
I
any
reviewed this with
objection?
my client, Your Honor. No objections.
Mr. Yanis, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports and no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge, we would waive PSI.
Anything you wish to say on behalf of your client?
I have, Judge, I've only met him briefly, but in my conversations with him, he is, he's regretful for his actions. He's already self-correcting. I have no doubt that he's going to be successful. While that 2-year recommendation from the state is a low one, I think he can be successful in that timeframe. You won't see him again. We just ask that you follow the agreement.
All right, so why are you speeding in a vehicle? How old are you?
21.
I'm sorry, when?
20?
20.
Yes.
And so you speed in a vehicle, a Dodge Charger. So I guess you loved hearing the engine rev.
Sorry.
And this is just what happened. And then you crash into a tree and you take off running. And the females in the car, was one of them your girlfriend? All right, who were the 2 females to you?
Just acquaintances
All right, just random people you picked up? How do you know them?
through a friend.
All right, people just pick up. I'm just living in a different time period where people just picked up friends of a friend. Do you even know them at all?
Personally, no.
All right. And so being a gentleman, that's just out of the question for you.
No.
You crash into a tree and you leave the 2 females behind. Did you even see if they were all right, or you just said you're on your own, bye?
I don't know. Sorry.
I'm sorry, what?
I said, I don't know what was going through my head at that time.
All right, you didn't even say bye to them. You just left. And why did you take off your shoes in the parking lot? Do you think that they wouldn't be able to,
No.
or did the crash shake you out of your shoes?
No, I guess I ran out of my shoes.
That's some fast running. Do you know what your time was? All right, maybe Olympics. I don't know.
Faster than the cops, Judge.
Yes, yeah, that's true. So are you employed?
Yes, ma'am.
What do you do?
Oh, I help on my dad, like doing tent, because he has his own business.
All right, and who did that car belong to?
My dad.
And how did your father feel when he found out you have just crashed his vehicle? And I'm sure it's not,
It was upset.
was it a total loss?
Yes, ma'am.
Mm-hmm. How far did you go in school?
I graduated high school.
What are you planning on doing with the rest of your life?
Well, trying to take over my dad's business so I could expand it.
How did you get here today? Did you drive?
Yes, ma'am.
And what are you driving?
My dad's other vehicle.
And what vehicle is that?
A Tom.
So what are we going to do about his driving? So give me a day-to-day. What's your schedule? You have places you need to be?
No, yeah, just so we'll work with my dad.
All right, so this is going to be your last. Do you live with your father?
Yes, ma'am.
All right, so this is going to be your last day driving for a while. I can't even believe your father would give you another vehicle to drive.
I think perhaps the father sees the regret that he has, Judge. The vehicle's important for him to keep track on his life. If perhaps maybe I suggest adding a defensive driving course for this young man. I know that the $800 fine is big. I know while the court is looking to put more on top of him, I would ask if you would consider probating a portion of that.
Oh, I'll probate the $800 fine, but as far as driving, see, this is what happened, I think. Parents too often give people vehicles and give their children vehicles and access to vehicles, and they haven't done anything to deserve it. There are people who are driving to high school in Lexuses and Cadillacs, and like the school bus is too good for them. People need to go back to letting their children be on a school bus and letting people walk to the school. I walk to school every day. Elementary school, junior high, now it's called middle school, high school, in college. I didn't get my first car until I paid for my first car. And I was in my 20s and I paid for it and I was in charge of insurance. Here you are wrecking a car into a tree. And this was August 2023. And you've already got another car that's your father's car. Yeah, he's not going to be driving for a while. It's going to be an $800 fine, probated.
Thank you, Judge.
He can do the defensive driving course. And they tell me you can complete that without a vehicle. There's to be no driving after April 15th until further notice. If you want to start driving again, you had better have completed the defensive driving course, and then your attorneys can file something and I will consider it. There's to be regular reporting by Zoom or in person. 120 hours of community service restitution. Do you have any children?
No.
Oh, that's good. Okay. Proof of employment.
You said that out loud, Judge.
Oh, no, yeah, it's good. He's not ready yet.
That's fair enough, Judge.
Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. If you're drug tested today, what are the results going to be?
30.
See, and everybody's saying he's doing good. And he's going to be dirty. What are you going to be dirty for?
Just marijuana.
You know what? But I appreciate you telling me that because many people will come before me and say, I'm going to be clean, and they know they're not.
I don't want to do that because I saw what you did to him, so I don't want I don't want that to happen.
All right, we're going to do regular UAs and we'll test for levels and test him every 2 weeks until the levels go down. Well, until it's a negative. And there's going to be 30 sober meetings in 30 days. Field visits, 1 time per month for 3 months. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No, ma'am.
All right.
Just have a question.
I'm sorry, just 1 second. And it'll be 2 years deferred adjudication.
Thank you.
Yes.
You said 30 days, right?
Yes.
Okay.
You have a question?
Was it okay if I drive from here?
Oh,
Or
yeah.
do I have to-
Today is going to be your last day driving. So don't go out there getting crazy because you're like, oh, it's my last day of driving. Don't do an Ed Norton, the last 24. Everybody should watch that. Or was it the last 48?
Just for clarity, Judge, can he go through a drive-through if he's not the one driving, just to be?
Oh, he can be a passenger. But I wouldn't suggest being a passenger with people you randomly know.
Yeah.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Okay, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right, we can go off the record. You're going to have to start making better decisions. Sometimes when people crash into trees, they die.
Yeah.
And now that tree is destroyed. All right, good luck.
In
to you.
Judge Boyd's courtroom, Jose Gonzalez has done nothing on probation. No payments, no programs, 1 dirty drug test, and then he disappears after his wife kicks him out and he ends up homeless. The judge shuts down his excuses, reminds him he could get 2 years in state jail, and gives him a brutal choice: 1 year behind bars or locked into inpatient drug treatment with extra probation and 120 sober meetings. If you were the judge, would you send him to prison or risk 1 more chance on treatment? Drop your answer in the comments, and don't forget to like, share, and subscribe for more real courtroom moments.
3955, State of Texas versus Matthew Ray Montalvo. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Roberto Ambrosino.
And are you Mr. Montalvo?
Yes, ma'am.
All right, defense has filed a motion for early termination. State, have you had a chance to review the motion? All right. Defense, do you have any witnesses?
I don't judge this argument.
All right. All right, I'll hear your argument.
Judge, Mr. Montalvo has been, when I understand, a model probationer since he's been on. He's paid all his fines and supervisory fees, or I'm sorry, his fines and court costs, and his current on supervisory fees. At this point, he's only, I think, reporting in person every 3 months. He's been extremely low risk. He's done everything that they've asked him to do. He's gainfully employed. He has his own business where he cleans pools. And to be honest, I've actually used him, and he's done a very good job and been very responsible and showed up on time. And I don't think that Mr. Montalvo is any type of threat to society. I handled the underlying case. It was basically marijuana-based ones. From what I recall, I believe that you would be a good candidate to be off probation this time.
All right. Probation.
Judge, Mr. Montalvo has completed everything that he needed to complete. Everything is seems fine on our behalf, and we have no opposition for determination.
All right. Is there anything you would like to say?
Feel like I learned a lesson and
All right, you want to raise your right hand?
yes, ma'am.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Matthew Montalvo.
All right, what lesson have you learned?
Not to do anything wrong, to be honest. Changed my life that day, and since then never really looked back. And somebody blessed me and showed me the pool cleaning business, and it's much more lucrative and less of a headache, I guess you could say. And I've been doing that for 4 years now, so I'm just looking to continue and expand. Brought my brother in now, he's working with me, so this was an eye-opening experience, and it was changed me for the better, I believe.
All right, and was $100 worth it?
No.
Anybody else with any questions?
Mr. Montalvo, my name is Hank Wilkins, and I'm the prosecutor here.
Yes, sir.
Have you ever been in trouble before here in Bear County?
Yeah, yes, sir.
Okay, so in 2007, did you get an evading arrest with a vehicle?
Yes, sir. That was my first arrest.
And what did you get on that?
Probation.
Okay, and were you successful in that, or were you unsuccessful?
I finished successfully, I believe.
Okay, so the records here, would you be surprised to learn that our records say that you were
Okay.
supervision term was finished unsatisfactory? Would that be surprising to you?
No, because I had 2 running concurrent. I don't recall which one was the first one to finish, and one had like 2 more months, and that one was the one I signed unsuccessful.
Okay, and so did you have a forging commercial instrument or check in 2009?
Yes, sir.
Okay,
That was-
and were you successful on that one?
That was the one that was running concurrent. That one, I don't recall which one was successful, which one wasn't.
So I'm not trying to trick you or anything.
Yeah.
Our records say that they were both unsuccessful.
Okay.
Your understanding is that you were successful on one, not successful.
That's what I was under the influence, yes.
So if your motion is unsuccessful today, do you think you would be successful? Do you think you'd be able to finish this out?
Oh, for sure. I mean, it's, during those trials or cases, I was 18 years old, young, not mature. I obviously was a lot older when this happened and made a bad decision. And I decided to do this one the right way and not mess around, not fail my UAs and have to go to boot camp, ZT, everything else, but just get it done. So that's why I buckled down this time and use it as a real learning lesson. So I try to do it all properly.
So as part of the steps in your case, it looks like you had more than 10, but less than 12 vapes, right? Okay, so were you, this for personal use? You selling those? What are you doing with that?
Judge, I'll object at this point. I don't really see how that's relevant to the motion for early termination.
All right,
Sorry.
just so everyone knows, I've read the stipulations, so. Objection overruled, but everyone, I've read the stipulations, so I know what happened.
So you can answer, Judge.
What was the question?
Yes.
Sorry.
So were you selling the vapes?
How do I say this without, so that was just a bad mistake. I was helping a friend out, who needed basically help, and that's where I went wrong. It wasn't for me. And I don't know if that makes things worse, but yeah. So that was all discussed when I was arrested. That I was in a time of need. I was just lost my job, needed some extra funds, and a friend asked me to help him out, and I made a bad decision. And yeah, that should all be written down. I explained that to the arresting officer, so.
So you made a deal with the state when you agreed to this term, right?
Yes, sir.
And you're asking that you're trying to change it now, right? That's what you're trying to do.
Well, I just felt
He'll
like,
object, he's
I-
basically asking for a legal conclusion. I mean, I don't remember not asking for early termination probation. being
Objective
part of the
speaking.
conditions.
All right, so everyone. You understand that you entered into an agreement for deferred adjudication for 6 years.
Yes.
All right, so now you're asking the court that you be let off early and not complete the 6 years. Okay,
may I,
now, just 1 second.
That's all, that's all.
All right, is there something else you wish to say?
what really brought me to this being here was my probation officers telling me repeatedly that I was gonna get an early termination. I just needed to do X, Y, Z, kept doing X, Y, Z, and it kept getting pushed next time we visit. So I just said, well, let me try to see what.
And I know you've been before the court before on an early termination and it's been denied. So let me,
With this.
yes. Yeah, no, previously, there was a motion sent to me for early termination. And it was denied, and that was back in October.
I was not aware.
Yes. Someone filed it and I denied it because that was, so. If you are tested today, what are the results going to be?
Should be clear.
The motion? And have you had a chance to confer with the state?
I did, Your Honor, and as well as.
All right, if you. Thank you. All right, everyone, we're about to go on the record. Court is calling 2021 CR 7282, State of Texas versus Charles Garley. Could I have parties announced for the record for the state?
Jason Beer, Your Honor.
Defense?
Mario Morano.
All right, and are you Mr. Garley?
Yes, ma'am.
All right. Defense has filed a motion for early termination. State, did you have a chance to review the motion?
I did review it briefly. Your Honor.
All right. Do you have any objections to the motion?
Yes, Your Honor, we're opposed to it.
All right. Defense, do you have any witnesses?
No witnesses, Your Honor, just argument.
All right, probation. Can you give the court probation's recommendation?
Ms. Farley has completed every confirmation. There is no opposition.
All right, defense, I'll hear your argument.
Thank you, Judge. So as far as I have been made aware from probation and from Mr. Garley, he has completed all terms of his probation with the exception of the completion of his term in limited, including but not limited to classes, community service. He's paid all of his fines, court costs, has checked in when requested or required. The only thing remaining at this point in time is for Mr. Garley to finish his remaining term. He was sentenced to a 2-year deferred term back in March of last year. So he's completed just a little over a year at this point in time. My understanding, he's been a model probationer. I worked with him in the underlying case as well. He's always been very prompt for court. Very respectful as well to me. I believe that at this point in time, Mr. Garley has proven himself to the court that he is ready, has taken responsibility for this cause, is ready to move past and move forward. And we're requesting that this time that the court grant his early termination.
All right, anything you wish to say?
No, ma'am, I'm just ready to put this behind me.
All right. I think you should probably say something because honestly, I'm leaning towards not early termination. I've read the facts of the case and I'm trying to figure out what was going through your thought process at that time. That's what I want to know.
Yes,
Can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
All right, you can lower your hand, state your name for the record.
Charles Garley,
All right, what have you learned?
keep my hands to myself and just to be a model citizen.
All right, so why did this happen? What was going through your mind? Because it appears that the officer was there for a disturbance.
I was not aware of that. I opened the door and I know the police were there and they barged into my home and I was trying to defend myself.
Well, what I'm reading in STIPs, and people correct me if I'm wrong, they come because there's a disturbance. There are 3 other people there, including you, civilians. You have a gun, according to the report, at your side.
Yes, ma'am.
One of the other civilians, because the officer asked you to put the gun down, you wouldn't. One of the other civilians there took the gun from you. So that diffused that situation. And then the officer was asking to talk to you and step outside. And then according to the STIPs, it says that you were swinging on the officer.
No, ma'am, I was not aware the officers were there. I was actually in shock because when I opened the door, guns were pointed at me. The reason my gun was out because somebody was in my home at the time that I did not want there. I asked them to leave, they did not leave. When, again, nobody in the house called the police. I think the disturbance was me trying to get that person to leave out of my home. When I opened the door, I didn't hear any knocking. I opened the door to let that person out of my home. And that's when the police were there. And I had my pistol pointed down. And that's when the officers pulled out their weapons on me. And I was in shock because I didn't know anybody was outside of my door. There was no knocking or anything. I had opened the door myself to let that person out.
Okay. So you open the door, you let the person out.
No, he did not leave. I opened the door to get him out. Like,
Okay.
like he needs to leave. And that's when officers were there. And I had no idea they were there. So I was in shock because guns were pointed at me. And that's the first time I've ever had guns pointed at me. So I was in shock.
But first time guns pointed at you by officers?
By anybody.
Okay. Any other questions?
I guess I would have a question, Your Honor, just to clarify, because you did say something, and I just want to, I guess, clarify for the court about the facts of what had occurred, if that's okay.
I'm sorry?
I said, I do have a couple questions just to clarify about the facts of what
Sure.
occurred, if that's okay with the court.
Yes.
So the judge stated that the officers were asking you to come out, but is that correct?
No, sir.
When they had drawn their weapons on you, and then you were at some point you were disarmed, is that correct?
Yes, sir.
And then did the officers ask you to step out, or did they enter your home?
They entered my home.
Okay. And at that point in time, is that when they tried to detain you?
Yes, sir.
And then that's when the physical dispute happened between you and the officers?
Yes, sir.
But you have taken responsibility for those actions back in March of last year, right? So you do understand that the way that things occurred between you and the officers at that point in time was unlawful.
Yes, sir.
And you understand, do you understand, and can you explain to the court how that probably should have played out?
I should have just complied and put my hands on my back.
I no further questions.
Any questions? All right, let me just tell you what I have in the STIPs here. And if there are some corrections, let me know, but this is what you all stipulated to. P1 knocked on the door. His sister stepped out and explained there had been an argument between her and you. P2 stated she was getting her stuff with the help of her family and that she didn't require the police to calm you down. While speaking to P2, I could hear P1 and S1 exchanging words to each other. When myself and the officer looked through the open door into the apartment, I could clearly see a silver handgun in the right hand of you. Myself and the officer both drew our firearms from our holsters and commanded the arrested person, well, S1, to drop his firearm. You ignored our commands. After commanding you a few more times to drop the weapon, then P2 reached over and swatted it out of your hand. At this time, we entered the apartment and stated to you he was being detained due to the nature at which he was displaying the handgun and the disturbance that had been occurring. You physically tried to close the front door on us and then physically resisted arrest by pulling away and pushing against both officers. We ended up pushing you onto the sofa, at which time you began to strike out at the officers. It says you were punching wildly and punched me once on the upper left side of my cheek during the confrontation, causing pain and some redness. I used physical force in order to gain control from you, including multiple closed fist strikes to the right side of the face. After being struck by myself and tased, eventually you were placed in handcuffs. So is there something that is wrong about that?
The only thing wrong with that is I didn't throw the first punch. When I was throwing the couch, the officer punched me in the face. And
I'm sorry, what did you say?
I said I did not throw the first punch. When I was thrown on the couch, the officer punched me in my face, and that's when I felt the need to defend myself.
Okay. All right, anything else?
Nothing from the state, Your Honor.
Nothing further.
All right, if you're
In Judge Boyd's courtroom, Charles Garley is asking for early termination of probation after an assault on an officer case. He says he's a model probationer now. But the police report says when officers responded to a disturbance, he had a gun at his side, fought them in his own living room, and ended up throwing punches after they tried to detain him. Charles insists he was in shock and only defended himself once an officer hit him first. Should a case like this ever get early termination, or should he be forced to finish every day of probation? Tell us what you would do as the judge. And don't forget to like, share, and subscribe for more real courtroom moments.
computer systems are down. And because people are so dependent upon technology, we forget what to do. It's sort of like when we were growing up and you first got the microwave, and of course, we were like, this is the most expensive popcorn maker we've ever seen. But once you got used to it, when the microwave went down, I'll never forget telling my brother, oh my gosh, how are we going to heat up the food? We don't have a microwave. Then my mom's like, Stephanie, we have an oven, we have a stovetop. I'm like, yeah.
There you go.
So oh yes. So even though the computer system is down, we will figure it out. All right, court is going to call 2023 CR 10497, State of Texas versus Yolanda Kaufman. Could I have parties announced for the record for the state? Defense.
I'm El Dapo for Yolanda Kaufman.
And are you Ms. Kaufman?
Same.
Yes.
All right, we have an interpreter here today. If you could raise your right hand. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
All right. Ms. Kaufman, all of the documents I'm going to review with you are in English. Were those explained to you in Spanish?
Same.
Yes.
And defense, are you fluent in Spanish?
Yes, Your Honor.
And were you able to explain the documents to your client in Spanish?
Yes, Your Honor.
And do you believe she understands the documents?
Yes, Your Honor.
All right. Counsel, have you received all the discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Are there no applications?
No applications.
All right. Ms. Kaufman, did you review what's entitled True Bill of Indictment with your attorney? Did you understand it?
Same.
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We're waiving the habitual enhancement, Your Honor.
Any objection?
No objection.
All right, did you review the document entitled Court Admonishments and Defendants of Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Same.
Yes.
It's better. it's
Did
better
you
to-
sign it?
I was just telling her, make sure you let her finish the question.
Did you sign it in all the appropriate places?
Same.
Yes.
Did you understand you're charged with driving while intoxicated, third or more? That's a third-degree felony. The range of punishment is anywhere from 2 years in prison up to 10 years in prison and up to a $10,000 fine. Did you understand?
Sí, señoría.
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Same.
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Same.
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Kaufman, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
No.
Anyone promise you anything other than the plea?
No, señoría.
No, Your Honor.
Are you satisfied with the way you've been represented?
Sí, señoría.
Yes, Your Honor.
Are you a U.S. citizen?
No, señoría.
No, Your Honor.
Counsel, did you advise your client of the consequences of pleading no contest or guilty in the application of federal immigration law?
We did, Your Honor. If I could add, just for the record, we had the court appoint an immigration attorney. She was contacted by the immigration attorney. She was advised two major things. Number one, that even though she's a permanent legal resident, she could get deported. And number two, after she is possibly deported, she could be denied reentry. Knowing both of those possibilities, she wants to go forward.
Is that-
A Padilla letter as well that we've gone over.
All right, is that correct, Ms. Kaufman?
Sí, señoría.
Yes, Your Honor.
All right, so you've been advised of the consequences of entering a plea in this case and as it relates to the application of the federal immigration law?
Sí, señor.
Yes, Your Honor.
And did that advice include possible consequences such as deportation, the denial of naturalization and exclusion from the United States?
Sí.
Yes.
And do you understand the immigration consequences of entering a plea in this case?
Yes.
All right, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Sí.
Yes.
According to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. Did you understand that to be the plea?
Sí, señoría.
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the paragraph entitled Waiver of Appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Sí.
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Sí, señoría.
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the office as charged, how do you plead? Guilty, not guilty, or no contest?
No me opongo.
No contest.
State, any evidence?
Your Honor, I offer State's Exhibit 1 and the attachments.
No objection, Your Honor.
All right, state, you may continue to confer. Ms. Kaufman, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Sí, señor.
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Sí, señoría.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Sí, señoría.
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. The court has reviewed State's Exhibits 1 and attachments. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
One thing we would ask, Your Honor, is that she does accept responsibility. She is an alcoholic, and she actually has her daughter in the back as well as her grandson. And they just want the court to know that they're here to support her in any way. There's a high possibility that she's going to be deported to Nuevo Laredo after she does her criminal time. And she's just trying to accept responsibility and be a success in the future.
All right, so with regards to, they're saying that she crashed into a building. Was there any restitution for that?
I know of no restitution, but there may have been some through insurance or something.
State, do you know if there's any restitution for the building? All right, thank you. It doesn't mention it in the steps. It just says she crashed in a building. It was a crash into a Goodwill.
We do restitutions, he needed.
No objection to that, Your Honor. Let me just explain to her in Spanish briefly what
Sure.
we're gonna ask.
Están poniendo en condición que va a ser la restitución.
She's in agreement, Your Honor.
All right. So the court will sentence you to 8 years in the prison, give you credit for any time served. There's to be a 2-year driver's license suspension. I'll request the therapeutic community, but you'll have to request it as well. There's to be restitution, if any, to the Goodwill located at 3400 Fredericksburg Road. Is there anything else with regards to sentencing?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Ms. Kaufman, if you are allowed back in the United States, you had better take care of this issue you have with alcohol. Otherwise, other things can happen. Usually people who are driving intoxicated, they don't hit buildings, they hit people, and the people they hit end up dying. You understand?
Yes, Your Honor.
All right, good luck to you. Thank you.
You're welcome, Your Honor.
Thank you, Judge. Excuse Your Honor.
In
Yes.
Judge Boyd's courtroom, a permanent U.S. resident mom just admitted she was so drunk she drove straight into a Goodwill building. Her third DWI. Now she's taking an 8-year prison deal, knowing that when her time is up, immigration can still deport her and bar her from ever coming back to her kids and grandson. Is that real justice for repeat drunk drivers or a life sentence for her entire family? Comment your thoughts, and don't forget to like, share, and subscribe for more real courtroom moments.